Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on all of these occasions on our heritage.org website, those that will be joining us via C-SPAN this afternoon. All of our internet and television viewers are welcome to send comments or questions at any time, simply emailing us at speaker@heritage.org. We will post the program within 24 hours on our website for your future reference as well. Hosting our discussion today is Hans von Spakovsky. He is our Senior Legal Fellow in the Center for Legal and Judicial Studies and manager of Heritage's Civil Justice Reform Initiative. He studies legal aspects of elections, such as campaign finance, voter fraud, voter identification laws, as well as registration issues. Before joining us here at Heritage, he served for 2 years as a member of the Federal Election Commission. He has also been a counsel to the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. He is a former litigator, in-house counsel, and senior corporate officer as well in the insurance industry. Please join me in welcoming my colleague, Hans von Spakovsky. Hans?
Well, ladies and gentlemen, I would like to welcome you to the Heritage Foundation, particularly all of you who braved the torrential rains we had in Washington overnight to be here in person, and welcome to our C-SPAN viewers also. We're here today to talk about the nuclear option. Now, anyone who lives in the real world outside of Washington would expect that we would have a panel here of our national security and foreign policy experts to talk about our missile defense system. But in fact, we are here to talk about another subject that was heatedly discussed on the floor of the Senate yesterday between Senator Reid and Senator McConnell. Senator Reid has now said that he intends to change the rules of the Senate to end the ability of the minority to filibuster, a long and hallowed tradition in the Senate. So what do we think about that? Well, here's what a certain senator said about this not too long ago. Quote, "The filibuster is not a scheme, and it certainly isn't new. The filibuster is far from a procedural gimmick. It's part of the fabric of this institution we call the Senate. It was well known in colonial legislatures before we became a country, and it's an integral part of our country's 214-year history. Senators have used the filibuster to stand up to popular presidents, to block legislation, and yes, even as I've stated, to stall executive nominees. The roots of the filibuster are found in the Constitution and in our own rules. There's no way that I would employ or use the nuclear option. It would ruin our country. In fact, breaking the rules to change the rules is un-American." Who said that? Senator Reid said that back in 2005. But of course, he has now scheduled his, to quote him, un-American act for a debate on Monday in the old Senate chamber and then a vote on Tuesday. Now, you may wonder, why is there a debate about this going to be in the old Senate chamber? Well, the old Senate chamber, for those of you who have not been in Congress, does not have television coverage, so C-SPAN viewers won't be able to watch it. And there won't be a gallery where the public can also see what's going on in the debate. By the way, then Senator Obama said that if the Senate broke the rules to change the rules, quote, "the fighting, the bitterness, and the gridlock would only get worse," close quote. Unlike a lot of the president's other pronouncements, he's certainly correct about this one. I also want to give you quotes just from a couple of other people. Senator Bill Nelson, Democrat of Florida, said, quote, "We must encourage compromise. To change the rules into the middle of the game is bordering on an abuse of power. Surely the Senate can rise above this partisan, highly ideological set of politics and come together for the sake of the nation." Someone else, another senator, Senator Tim Johnson, Democrat of South Dakota, pointed out the reason why this is a good rule. He said one of the consequences, and again this is a quote, of the 60-vote rule is that it takes both parties by the scruff of the neck, brings them together and says, you will have to reach across the aisle and cooperate, coordinate with your colleagues from the other political party, whether or not you like it. Finally, I'll quote Dick Durbin, Democrat of Illinois, who said, "Those who are forcing this nuclear option on the Senate are not just breaking the rules to win, but they want to break the rules to win every time." Now, this final point is very important because Senator Reid and his caucus are saying that these rules have to be changed because the minority has been holding up legislation and blocking the president's nominations. But President Obama has been able to get signature bills through, everything from Obamacare to his latest immigration bill. And the vast majority of the president's executive nominees and judicial nominees have all been confirmed. His very minor loss rate isn't any worse or any different than that of prior presidents like President Bush and President Clinton. Just a quick example, he's had 201 judges confirmed, including 2 Supreme Court nominees. 29 have been confirmed this year alone. That's 38% ahead of the annual pace since 1976. If that's a blockade, it's a mighty porous blockade. This is a very serious subject, but I do have to put a personal note in here. I actually laughed at one point yesterday during the C-SPAN coverage of the debate. There was a discussion ongoing at that time of President Obama's recess appointees to the National Labor Relations Board, which, as you all know, the District of Columbia Court of Appeals found to be unconstitutional because the Senate was not in recess at the time. In excusing these appointments, Senator Reid said they were necessary at the time because, to paraphrase Senator Reid, due to the unconscionable delays in the consideration of the nominations of these NLRB nominees by the minority. Now, what's interesting about that is that 2 of the NLRB nominees he was speaking of were recess appointed on January 4th, 2012. When were they nominated by the President and their names sent over to the Senate? December 15th, 2011, 2 weeks before. The reason I laughed is because of my personal experience. Senator Reid now believes that 2 weeks is an unconscionable delay, and yet it was the same Senator Reid that held up my nomination during a prior administration for 2.5 years after then Senator Obama put a hold on the nomination. The point here is that the claims being made that the rules should be changed because all of the president's legislation nominees are being stopped and that the president is suffering disproportionately in comparison to other presidents is factually untrue. So why is this being done, you may wonder? Well, I'll end by telling you that I would suggest that you read a very interesting article that may give you a clue to this. It's in Mother Jones magazine, which is not a magazine as a conservative I normally recommend people to read, but they had an interesting article on January 9th of this year in which they described a meeting that was held in Washington a month after the November election. Some of the most powerful liberal advocacy groups and unions in the country were at this meeting, including the National Education Association, the Sierra Club, the SEIU, the NAACP, and the AFL-CIO. The dozens of these organizations at this meeting are the backbone of the liberal political world, and they provide the money, the support, and the get out the vote campaigns that keep Senator Reid and his caucus in office. The goal of this meeting was to put together, quote, a national coordinated campaign, close quote, to reshape the United States into a progressive liberal utopia. And of the 3 objectives that were agreed upon by these groups at the meeting, one of them was to get rid of the filibuster in the Senate so that the majority party could ram through legislation and nominees with no opposition and no need to compromise with the minority. Now, to discuss the history of the filibuster and the dangers of getting rid of it, we have 3 very knowledgeable sources. I'm going to introduce all 3 of them, then ask them to speak. Brian Darling, to my left, is a veteran of the Senate, and he served on the staffs of Senators Steve Sims of Idaho, the late Paul Coverdale of Georgia, and Mel Martinez. He's currently counsel for Senator Rand Paul of Kentucky. He's an attorney who also serves Senator Bob Smith of New Hampshire as his counsel on the Senate Judiciary Committee, and a fellow 7-year veteran of the Heritage Foundation, where he started as Director of Senate Relations for our Government Relations Department and ended as a Senior Fellow for Government Studies. He authored, by the way, 2 backgrounders for the Heritage Foundation that are relevant today. There were copies outside for those of you who came in, and for anyone watching, you can get these on the Heritage website. One of them is called Tyranny in the United States Senate, and the other is The Filibuster Protects the Rights of All Senators and the American People. Robert Dove, to Brian's left, is the parliamentarian emeritus of the Senate. He served as the parliamentarian from 1981 to 2001 with a brief interlude as a legislative consultant to Republican leader Bob Dole. He was the assistant parliamentarian from 1975 to 1981 and the second assistant parliamentarian from 1966 to 1975. Bob, I hate to tell you how old I was in 1966 when you started doing your parliamentary work in the Senate, so I won't tell you that. But he's also worked as a parliamentary consultant to the Russian Duma and parliaments in Yemen, Kuwait, Bulgaria, Poland, and a host of other countries. He has taught at George Washington University, at Georgetown University's Law Center, at George Mason University, and a number of other universities. He's the co-author with Richard Ehrenberg of Defending the Filibuster, The Soul of the Senate, which is available at Amazon.com. And then last but not least, we're going to have James Wallner. He's worked in both the House of Representatives and the Senate. He's currently the executive director of the Senate Steering Committee. Prior to this, he served as legislative director to two U.S. senators, Jeff Sessions and Pat Toomey. He's been included on Roll Call's Fabulous 50, a list of the top 50 staffers on Capitol Hill. He's also an adjunct professor in the Department of Politics and the Congressional and Presidential Studies program at Catholic University, and the author of a forthcoming book, The Death of Deliberation, Partisanship, and Polarization in the United States Senate. He's also published articles in the Journal of Legislative Studies and the Forum, a journal of applied research in contemporary politics. And Brian, I'm going to turn it over to you, and you all can speak either from the podium or from there, however you'd prefer.
I'd probably prefer to sit down, but I think everybody else is going to end up speaking from the podium, so I will. I will speak until I no longer can speak. And how much time do I have again? Do I have 13 hours or not?
No, you don't.
Okay. Well, just to be clear, I'm somebody who spent 7 years here at the Heritage Foundation and wrote quite a bit about the filibuster, and my opinion of the filibuster is pretty simple, is that it protects transparency. You just look at the whole idea of the filibuster, and what are we talking about? We're talking about extended debate. Right now, there are nominations that have been filed cloture on by the Senate Majority Leader, and not one word in the Senate floor has been commenced on that so-called filibuster. Very frequently in the Senate, you have a kind of, I call it a fake filibuster, where you don't really have any debate happening, and you have the Majority Leader filing cloture on a nomination before a word is spoken. So I know that when you get into these issues, it gets complicated. The Senate rules are complicated, but to take it back a step, it's very simple to understand that what does a filibuster protect? It protects the American people to actually participate in this process, to understand what their government's trying to do, and to actually know something about these nominees before they're confirmed, because they're not here inside the Beltway in Washington, D.C. They're off watching it on C-SPAN, reading about it in the paper, and if cloture is filed and you have 2 days to figure out a nomination, something about a nomination that's on the Senate floor, you don't really have much time to get up to speed in that. And I did write 2 papers for the Heritage Foundation. One was The Filibuster Protects the Rights of All Senators and the American People. Wrote that in January of 2011. The theme of that was that the filibuster in the Senate protects the rights of senators to debate and amend legislation, thereby protecting the interests of the American people. The filibuster actually realizes the founders' intent that the Senate slow the legislative process to ensure deliberation and inquiry before passing a bill. And make no mistake, if the filibuster is tossed aside for nominations, even if it's just for executive branch nominations, it's not too difficult to see where that extends to judicial nominations and right over to legislation. Because if you look at the Senate rules, there's no distinction in the Senate rules and the cloture rule between judicial nominations, between executive branch nominations, and legislation for that matter. The other paper I wrote was Tyranny in the United States Senate, which I wrote in June of 2012, where I argued that the Senate Majority Leader has regularly used a procedural tactic called filling the amendment tree to restrict senators' right to debate and offer amendments. And my point there was that you have a situation on the legislative side now where the Majority Leader, and it's not unique to the current Majority Leader, it happened in the past, but it's happened a lot more recently, where the Majority Leader brings up legislation, offers amendments that make technical changes to the bill, no substantive changes, for the sole purpose of blocking other members of the Senate from participating in the process, offering amendments, having extended debate, and actually being senators and having a say in what goes forward either to the House or to the President. Here's what's happening right now. In my opinion, the left wants to seize more power. And they want to do so, they want to load up the executive branch, maybe the judiciary, and maybe they'll go forward with legislation to forward a liberal agenda. And this is going to be something that will take Republicans now. Maybe it'll be Democrats in the future, but right now it'll be Republicans, and kick them to the side. And your senators, the rights have been chipped away by not allowing them to offer amendments, not allowing them to engage in extended debate. The Senate's becoming more like the House every day, where members don't have the power to get up, give a speech, offer an amendment, debate until they run out of breath, until they can't speak anymore. And that's something that's not good for our republic. And when you look at what's happening now, you're hearing breaking the rules to change the rules. What does that mean? The rules are very specific, and they're mapped out. The cloture rule, Rule 22, when you read through the rules, you read the wealth of rules in the Senate, and you see the Senate operating on a day-to-day basis, you hear them frequently asking unanimous consent to waive a rule here, waive a rule there. And that's the way the Senate operates. It has very strict rules, but they're consistently waiving those rules by consent of all of the members of the Senate to move forward. Well, what this would do is it would change. It would make a substantive change in the text of the rules, and it would do so with a majority vote. And you are allowed to change the rules in a majority vote, but to do so, the way that you're supposed to do so is have actual debate on changing the rules. And during that debate, you need a 2/3 majority to shut down debate. And why doesn't the Senate really hasn't been doing much over the past week. They've had a couple votes, and there's not much that we know of coming up in the next few weeks. Why not have that debate? Let's have a debate for a week on the actual changing of the Senate's rules instead of using these nominations as a pretext to break the rules to change the rules. Now, you hear the nuclear option. What does that mean? What does that specifically mean? Well, Richard Beth of the Congressional Research Service wrote in March of 2005 that beginning in the 108th Congress, the term nuclear option has often been used to refer to a procedural course of action that would meet this requirement of bypassing the obstacles posed by the usual procedures for considering procedural changes. Critics of this form of action, however, have used this term to connote a unilateral resort to such a course by a majority that might undermine traditional practices of comity within the Senate, especially the expectations of predictability through consensual arrangements that have heretofore been held to characterize the body. You hear nuclear option, where it came from was what happens when one side seizes power and takes the minority and says, you can't participate anymore, you can't debate, you can't offer amendments. You get into a mutual assured destruction situation where then the minority will use all their rights to gum up the process, to block everything that happens in the Senate, and the Senate becomes a dysfunctional body. As I said before, Senate operates by unanimous consent to do so many things, and that goes away if you have mutual assured destruction if the nuclear option trigger is pulled. Now, Greg Sargent previewed this in the Washington Post a few weeks ago on May 17th of this year when he wrote that Senate Majority Leader Harry Reid is increasingly focused on the month of July as a time to exercise the so-called nuclear option and revisit filibuster reform. He has privately told top advisors that he's all but certain to take action if the Senate GOP blocks 3 upcoming key nominations, a senior Democratic aide familiar with the talks tells me. Reid privately consulted with President Obama on the need to revisit filibuster reform, and the President has told the Majority Leader that he will support the exercising of the nuclear option if Reid opts for it. The aide says that the senior Democrats expect the President to publicly push for it as well. If Senator Reid decides to do something in nominations, the President has said he will be there to support him. Now, this talks about nominations. We're right now dealing with executive branch nominations. Pretty clearly, this initial push was not limited to executive branch. it's something that will bleed over into the judicial branch, and we will see judicial nominations probably being subject to the same thing in the future. Now, how does this all play out? We've got 7 nominations right now that Senate Majority Leader Harry Reid filed cloture on. We have Richard Cordray to be director of the Bureau of Consumer Financial Protection, Richard Griffin to be in the NLRB, Sharon Block to be in the NLRB, Fred Hochberg to be president of the Export-Import Bank, Mark Gaston to be NLRB, Thomas Perez, Secretary of Labor, and Regina McCarthy to be administrator of the EPA. Now, these nominees for the National Labor Relations Board are very controversial after the court ruled that Obama recess appointments of 3 members were invalid. Richard Cordray also was part of a recess appointment, but that wasn't subject to the lawsuit. And the Supreme Court is going to be deciding the NLRB cases. This action would probably moot those cases, take them out of the courts, and that's clearly in the interest of this administration not to be embarrassed by the Supreme Court if they were to come out with a decision contrary to what they want. Now, let me just close on this. I don't know how this is going to play out. I'd love to hear other members of this panel talk about how this games out and how it actually happens to understand specifically how the nuclear option would come to play. You know, what happens on Tuesday morning if there's no agreement? How does it play out? Is the threshold merely lowered from 60 to 50 votes on a motion to proceed, or will all extended debate be declared dilatory? And just to think about 2 things. I want you to keep in mind 2 things. When you look at this year, 2 of the biggest things that happened politically were filibusters. And you hear this demonization of the filibuster. Oh, it's terrible. It slows everything down. It blocks legislation. Well, my boss, Rand Paul, filibustered on the Senate floor for 13 hours. And that raised every American's awareness of the potential use of drones domestically here in the United States. I mean, that was an issue that was raised. The American people heard it. They were educated on it, and we're having a national debate on that. And in Texas, the debate over abortion was raised by an individual getting up and filibustering legislation in the Texas state legislature. I mean, those are issues that are in the public domain because of the filibuster. And if either party, back in 2005, Republicans considered doing this. Now, 2013 Democrats are. Both parties shouldn't consider doing this because it's going to ultimately destroy the nature of the Senate. It hurts our republic when you go down this road of making it very easy for the majority to steamroll the minority and not even allow them to participate in the process. And it would be really unwise for this to move forward. Thank you.
Bob, you want to speak from there?
Sure. I came to the U.S. Senate in 1966 when the Senate was run by 2 leaders, Senator Mike Mansfield of Montana, the Majority Leader, and Senator Everett Dirksen of Illinois, the Minority Leader. It was a very different Senate then. The filibuster was attacked then because of the issue of civil rights. And I remember just about 9 years later, in 1975, when a Republican vice president, Nelson Rockefeller, together with a bipartisan group led by then Senator Walter Mondale and then Senator from Kansas James Pearson, Republican, led a fight which basically was the nuclear option. And they were successful. And they changed the cloture rule from 2/3 down to 60. Now the proposal, I guess, is to change the cloture rule down to 51. I am co-author of a book entitled Defending the Filibuster. I wrote it with a gentleman who worked initially for Senator Paul Tsongas of Massachusetts and stayed on the Hill for 30 years, ending up working for Senator Carl Levin of Michigan. And the reason we wrote this book is we saw the benefits of the filibuster. When Rich Ehrenberg, who's my co-author, came into the parliamentarian's office in the late 70s, we knew that in order to pass a bill that Senator Tsongas was very interested in, called the Alaska Lands Bill, that the Republican senator, Senator Ted Stevens, would have to sign off on it if we were to get cloture. And this forced a bipartisan approach to that bill. And the result was that that bill was adopted and signed by President Carter, but has been a successful bill over the years. And I would contrast that with the bill called the Affordable Care Act, which was pushed through by Senator Harry Reid without any bipartisan support. Now, for one golden moment, that was possible because Senator Reid had 60 votes in his caucus due to the change of parties by Senator Arlen Specter, and suddenly he had 60 votes. And he was able successfully to push through that bill. And I would contrast those two bills in terms of their support in the country. I don't think it's a good thing for bills to have no support from the two parties. And basically what happened in the Affordable Care Act was that the bill only had support from the Democratic Party. So that's one of the reasons we wrote the book, Defending the Filibuster. Now, it is true that right now, Senator Reid does not have 60 votes in his caucus. And he is supposedly going to use, quote, the nuclear option to change all of that. Now, this is not the first time this issue has come up. When Senator Bill Frist was the Senate Majority Leader and was being frustrated by votes on judicial nominations, he proposed the nuclear option. And the result was that a gang of 14, 7 Republicans and 7 Democrats, worked together and came to the floor and said, no, we're not going down that road. And that was enough to stop Senator Frist. I would hope that as a result of the caucus on Monday night, there might be a similar group that would come to the floor and say, do not go down this road. I can tell you, having seen what happened in 1975, when the Senate did go down that road, the repercussions lasted for years, and the bitterness lasted for years. It's not something I would ever wish for the United States Senate. The Senate is an institution that I love. I worked there for 35 years. I now teach about how Congress works at George Washington University, and I honor the Senate. I can remember, frankly, that when this was proposed by Senator Frist, I went on the CBS Evening News and suggested that if a group of senators would come to the floor and say, "Stop the madness," we could stop it. And that's exactly what happened. And that's what stopped Senator Frist. I sincerely hope that that is what happens after that caucus on Monday night, and a group comes to the floor and says, "Stop the madness." Okay?
James.
Good afternoon. Thank you to Heritage for hosting us, and thank you for letting me appear with these distinguished panelists, especially you, Bob. Since I'm going last here, I thought I would take a step back and try to put the current situation into context and try to help provide a framework in which we can think about what both Hans and Brian and Bob have said. And I think, and hopefully, that this will help us understand how we arrived at where we are today. It'll help us understand why I think it's basically impossible to limit the use of the nuclear option in this instance to executive nominees, which is what the majority has claimed they would like to do. And then lastly, and I think perhaps most importantly for the long-term health of not only the institution but also the republic, why I think, and this might seem a bit odd at first, why it is ultimately impossible to transform the Senate into a purely majoritarian body like the House of Representatives. And because of that, I think this should give the current majority pause in their efforts. Because if they do go through with this, it may actually result in even more dysfunction in the end without ever arriving at the end point at which they would like to. I think first here, imagine a continuum, right? And let's think back to college or to high school. And you know about the House and you know about the Senate. But think of that continuum as a rules-based continuum to like a relations-based continuum or relations-based governance. The House is obviously more rules-based, and the Senate is more relations-based. In the Senate, formal rules are sparse. Informal rules govern things. This is what Bob did for his career. Precedents, norms, traditions, acceptable behavior. And this tells us something very important about the legislative process. In the House, the legislative process is rules-based, and it's very perfunctory as a result. The important decisions are made well before they get to the floor, and the floor stage today is largely just to ratify those decisions. In the Senate, though, the legislative process is critical. And because of that, you often see, as Bob has alluded, large bipartisan majorities support legislation once it goes through that process in the committee and on the floor. And this is really important for the current discussion, I think, and the current issue of the nuclear option and what's going to happen next week. Because the legislative process in the Senate reveals very important information about the level of resolve of both sides, right? About the majority and the minority, or Democrats and Republicans. And because of the process by which legislation is considered, the minority learns a lot of really important stuff about how hard majorities are willing to push to get what they want. And vice versa, the majority learns a lot of important information about how hard the minority is willing to push and to react if the majority tries to restrict their rights in some manner. And that this process in the Senate has worked reasonably well throughout the institution's history, I would think. However, today in the contemporary Senate, we have a problem because the legislative process no longer performs these goals. It no longer performs this function. Today, the process is almost completely broken down. It's almost non-existent. And because of that, Senate majorities, or I should say Senate majorities, have largely acted to produce this by trying to achieve policy outcomes without the input of Senate minorities and even over their objections. And if you see this, I mean, if you look at what happens in the Senate, the number of total amendments proposed to legislation on the floor, amendments that a senator goes down to the floor and offers to a bill, has declined from just in the recent history, 2,116 in the 109th Congress to 974 just last Congress. If you look at just minority amendments, the number of minority amendments proposed to legislation on the floor has declined from 1,043 in the 109th Congress to just 400 in the 112th. And I think more importantly, the number of recorded votes on amendments has declined from 428 in the 109th Congress to a paltry 228 in the last Congress. And so when this happens, when there's virtually no floor process, the legislative process no longer tells us much about what each side thinks is really important and how hard they're willing to push to achieve their goals and fight. And when that happens, the current way of business creates dysfunction, because in a relational body, when you don't have a lot of rules to tell you what you can and can't do, you have a lot of leeway to do things. And so now both sides have incentive to use all of that leeway to persuade the other side that what they want to do is very, very important, and they will push as hard as they can to possibly get it. So what does this have to do with where we are today? Well, number one, the current situation is unsustainable, and the way we consider bills on the floor does absolutely nothing to tell us what each side thinks is important. I think how this situation is resolved next week will encourage Senate majorities to employ the threat of the nuclear option in the future in order to produce desired behavior from Senate minorities. And this reinforces a dynamic that we've really seen, because this is no surprise that we are where we are today. We have seen this dynamic play out over the years. In just January of 2011, beginning of the 112th Congress, the Senate, to diffuse a very similar situation, passed a compromise rules proposal. We eliminated the requirement that amendments be read, and we eliminated the practice of so-called secret holds. The Senate also reformed the executive nominations process, whereby some nominations were removed from the confirmation process entirely, and others were given a new special expedited process. In exchange, the minority was given a gentleman's agreement, whereby if they refrained from filibustering a motion to proceed, the majority would allow them to offer amendments. That gentleman's agreement, as we know, quickly fell apart. Fast forward to October 2011, a precedent was created several years ago whereby the minority could offer non-germane amendments post-cloture on a bill because they had been shut out during the regular course of business. Well, Majority Leader Reid decided he didn't like that, so he employed the nuclear option to get rid of that precedent. Fast forward to January 2012, the president disregarded the Constitution and unilaterally made 3 recess appointments, even though the Senate was clearly in session and the D.C. Circuit Court has agreed. The Supreme Court has decided to take up that case. Fast forward to just this year, in January of 2013, there was yet another bipartisan rules agreement designed to diffuse tension and to discourage the majority from, quote-unquote, going nuclear. But I would argue that none of these instances, and especially the negotiated compromises that were meant to forestall where we are today, actually worked. In fact, I think they may have made the situation even worse. And this is why we can't restrict what's happening next week, if it does in fact happen, to just executive nominees. Because the minority will be in a worse position after that, despite having cooperated in all these other instances in the past, because the majority learns a lesson each time, right? The majority is rational, and it says this works. If we threaten, if we bluster, if we beat our chest, the minority will give in. They will give us what we want. Right now, I think we're seeing that understanding unravel, but they can still take that lesson from this situation. And if they do, you could see this threat employed again on D.C. Circuit Court nominees. You could see it employed again on a Supreme Court nominee. You could see it employed on controversial legislation. There is no rational reason why they would limit themselves to just executive nominees. And this brings me to my concluding point on why I don't believe the Senate can become the House. And this has everything to do with the presiding officer. Despite the wishes of the current majority, the Senate can't become a truly majoritarian body like the House. And this is critical because the nuclear option, whereby they would effect that change, is dependent upon a complacent and complicit presiding officer. Yet the Constitution stipulates that the Vice President is our presiding officer. The majority doesn't get to choose them. And this is problematic because in a majoritarian rules-based body like the House, you have to have a strong presiding officer. You have to have a speaker to enforce order. And throughout its history, in fact, all senators in all parties, majority and minority, have been hesitant to bestow on their presiding officer significant powers to enforce order. And this is because the Vice President is not a member of the Senate. He may not be a member of the same party as the majority party. And even if he is, it's not entirely clear he'll have the same priorities as the majority party. So what does all this mean? If, in fact, the nuclear option is employed next week, I think it'll go a long way towards destroying the comity on which the Senate, or the relational aspect of Senate decision-making is based, and it'll further shift the Senate towards this rules-based model of governance that the House follows. However, the Constitution stipulation that the Vice President is our presiding officer will prohibit us from getting all the way there. So what will happen is that we'll be in this weird no man's land where the result will be an even more dysfunctional body that cannot operate at all because we don't have a strong presiding officer like the Speaker, but yet the comity that a relational body, the comity that Bob referred to, is gone. And so we're in this weird no man's land where it's very difficult to do anything. And that would be bad for the Republic, and it would be terrible for the Senate. Thank you.
All right, now we'll be happy to answer questions if anyone has one. The one thing I'd ask you is wait for the microphone so that our viewers around the country can hear your question, and if you would just identify who you are when you ask the question. And I would ask one thing, and that is to ask a question, please, and not make a statement.
Can I ask one from the podium?
Yes, of course.
I really want to ask these guys to game it out. What do you think is going to happen? I think Bob would have a great perspective on what is actually going to happen on Tuesday morning. How does this play out? How do you see it going? And this presumes that there is no gang that comes out of the Monday night discussion.
Well, unfortunately, what I think is going to happen is that Senator Reid is going to play out this game. And the result, I think, will be disastrous.
You want to add anything to that, James?
I would agree.
All right, any questions from the audience? Yes, right there.
Baker Spring with the Heritage Foundation. I guess this is primarily a question for James, although the other two panelists I think might want to comment on it too. You talked about the merits of the filibuster in its own right, whether there's a question of employing a nuclear option to change the rules on it or not. But we know that within the context of the Senate rules today, there is a majoritarian approach with regard to the budget. To what extent do you think that the legislative dysfunction is resulting from that particular element of Senate rules as it applies to the budget, and therefore to the broad array of legislation in terms of the relationship-based decision-making process that you alluded to?
Right. I think the budget is a great example of why rules aren't a panacea. Right. The budget is a majoritarian document in the Senate. A majority can pass it. We didn't pass one for several years. We did finally pass one. We are still far apart from any sort of agreement on a budget with the House. It goes to show you that significant conflict can still exist even in a majoritarian body, and dysfunction can still exist even in a majoritarian body. So.
All right, next question.
Could I just chime in, because I helped write the Budget Act. I was part of a group that Senator Byrd called in to his office to go through the Budget Act and make sure that, quote, it worked. My contribution was writing into the Budget Act what was then the standard unanimous consent agreement, providing that amendments had to be germane, that there was a limitation on the time of amendments, providing that the motion to proceed would not be debatable. I will tell you that in the 1970s, when that act was written, there were many attempts to overcome the idea of Senate filibusters. And that was just one of them. The War Powers Act was another. The whole idea of the legislative veto was very popular in the 70s. And many things were written into law that avoided a filibuster. This was seen as a way of getting around the problems of dealing with Senate bills on the floor. Unfortunately, I can tell you that our intentions were good. But by creating something called the Reconciliation Bill, we created a monster. Again, a bill that can pass with only majority support and has been repeatedly used by various presidents. The whole idea of the budget process was to cut the president out of the budget. But presidents have learned they can use this budget process. Whether it was President Ronald Reagan, who got through his budget program, or President Bill Clinton, who got through his budget program, or President George W. Bush, who got through his tax cuts. Bills that would never have passed had they been subject to a Senate filibuster. And in that sense, there is blood on these hands because I helped create it. I'm sorry.
Sorry, that wasn't my intention.
Okay.
Yes. Oh, I'm sorry, I couldn't see behind the post.
No worries. My name is John from Senator Johan's office. This question is for Mr. Dove. It's unclear to me that there's anything that would limit the applicability of the precedent that we're talking about to certain types of nominations on the executive calendar. Is that your view? Is there anything that the parliamentarians'
That
office
is exactly my view. My reaction is you go down this road and you have turned the Senate into a majoritarian institution. And you have made it much like the House of Representatives. And then my reaction is the Senate was never intended to be like the House of Representatives.
What types of things would the parliamentarians' office consider when evaluating the breadth of the applicability?
Unfortunately, if you look at what the ability of the parliamentarians' office to control what the chair has said, I came to the Senate when the Vice President of the United States, Hubert Humphrey, cared not a whit for the advice of the Senate parliamentarian and made rulings consistently that were against the advice of the parliamentarian. My reaction is that a determined vice president can return to that model. Now, the problem with that is that suddenly the vice president plays a role which, frankly, hasn't been played since Hubert Humphrey. I mean, Hubert Humphrey had no role in the Johnson administration. He was totally shut out. And so he found himself a home in the Senate. Since Jimmy Carter gave Mondale an office in the West Wing, vice presidents have really enjoyed, in effect, becoming part of the executive branch. I don't know whether Vice President Biden would enjoy reverting to the vice presidential role of Hubert Humphrey or not, but my reaction is he would have to if he were going to play that role.
All right, here in the front.
Hi, Andrew Cluster, Heritage. I have I would like Mr. Darling's thoughts. If you could share maybe a little more information on your boss's filibuster, maybe some background.
Sure. Yeah, again, you know, the filibuster's been demonized so much, but I think most people look at that as a good use of the filibuster. And it's funny, it's been perceived that it was a filibuster of the nomination of John Brennan, and it was in a sense, but it wasn't also, because for him to get the floor and do what he did, he was actually blocking the majority leader from filing a motion to proceed to getting the floor, being recognized, and moving to proceed to that nomination. And I'll tell you, it's out in the public domain. He's written an op-ed in the Washington Post about how it played out. But I can tell you, he didn't plan on speaking for 13 hours. And he jokes that he wasn't wearing his comfortable shoes. He just was on his way to the Senate floor. he had done some preparation for the filibuster that he wanted to do, but it wasn't intended on being on that day. It was intended on being on the next day, and he surely didn't intend on talking for 13 hours. But as he went on, I was down watching him, and he spoke, and it was amazing to me that he can speak for hours on end off the cuff. He did have notes. He was reading op-eds, and that was spurring thoughts. But it was amazing to see him go off the cuff for an hour at a time. And then I think it kept him going when other senators came down to the floor and asked questions of him. Senator Ted Cruz and Mike Lee were the first two to come down and ask questions, and they had a back and forth with question and answer. He couldn't yield the floor at any point. He could yield for questions, and so he did yield for questions. And as you all saw, if you watched it, there were many senators that came down. Senator Ron Wyden of Oregon was a Democrat who came down to ask questions too, to get involved in that. And it's just an amazing thing to watch, but it shows that with all the demonization, the evil filibuster, obstructionism, all the terrible things, that was a good thing, and that educated, and that helped get the American people talking about the drone issue. And it's something that has raised that issue to the level where it's talked about more so than it was before, and that was important. It did spur a response from the Obama administration, and I think by the end of it, he was weary, and I don't think he's excited to go back and run down and do that again anytime soon, because it did take a lot out of him. But it was a great opportunity, and I think a lesson for a lot of people. And one of the roles of the Senate that is underreported is talking, educating, getting people involved, getting people to think about issues that they may not have thought about before.
If I could just comment, to me, the glory of the Senate are the people like Rand Paul. I remember when Senator William Proxmire left the Senate. He had single-handedly stopped a project called the SST, and he had done it by talking. And it is just something that, the House has no rule that allows people to talk. Only the Senate has a rule that allows people to talk. And if you get rid of that, to me, you have gotten rid of the Senate.
And I would just add, it's not just talking, right? We've already seen the restriction in your ability to propose amendments, germane or otherwise, on the floor. That's going to continue even more if they get rid of the filibuster for executive nominees and potentially other things. And it's the ability to talk. But both of those are crucial planks in what makes the Senate great.
Down here.
I'm Barbara Ledeen. I hear all of you talk about, if this happens on Tuesday, what the result will be theoretically. What will Republicans do you think, if Reid goes forward with this and wins? What will be the response?
It will not be pleasant. You will have poured poison into a well that will be there for years and years and years.
Well, that was kind of my first question too. It matters what happens, and I think it's still unclear what exactly happens. Are we going to have Reid go down to the floor and say, extended debate is dilatory, I'm shutting it down right now? Is that what he does? Or does he just say that the 60-vote threshold on nominations is unconstitutional, needs to be by precedent lowered to 50 votes or a simple majority? Because if that happens, if you still have the cloture procedure intact and it's just a threshold that's lowered, you still have the opportunity to have post-cloture debate time on the nomination for 8 hours, and with 7 nominees, you multiply that out. That could take a while. And so to me, it's still unclear exactly how this is going to play out, because we don't know what the precedent is going to be going forward. I don't think, maybe some people know, but I have not seen in the public domain exactly what Reid is intending on doing.
And I would just like to say that I think how the minority responds is just as important as whether or not Reid goes forward. Because if the minority chooses not to respond, or to respond in a way that does not cause discomfort with the majority, then the dynamic that I laid out since January of 2011, if not before, continues. And we find ourselves at another crisis point in the future.
I would not count on Senator McConnell not responding.
All right, we do have time for some more questions. Anyone else? Yeah, sorry, go ahead.
Hi, I'm Michael Casey from the Mansfield Foundation, and while I share your concerns and the complaints to the minority party, I don't think that we've really discussed the role that the minority party has had in getting us here. That I feel that there are legitimate complaints or criticisms that the majority is making, that it takes 9 months for the average nominee to be, to have a vote upon them. Gina McCarthy has to fulfill 1,100, written responses at the EPA. So if the panel could talk about or respond to some of the criticisms that the majority is making.
Oh, I leaned forward first. That was my mistake. I'm just ask. I think both parties are guilty of it. Both parties obstruct. Look what happened in 2005. I mean, Democrats were obstructing. Ask Miguel Estrada. Ask John Bolton about obstructionism. And Democrats, for the most part, were rewarded, if not, maybe just not punished. I mean, I think when you get into nominations, your average American's eyes glaze over, unless if you're talking about a cabinet-level nominee or a Supreme Court nominee. So, you get into these NLRB nominees, I don't think they're decisive political issues, but I don't think anybody's been punished for slowing down nominations. And many times, look at Hochberg, who's being nominated to be president of the Export-Import Bank. I'm sure there are members of the Senate that want to block his nomination. Why? Because they don't like the Export-Import Bank. And so they want to slow that process down, or they want to slow the process down of the NLRB or other institutions. And that's just part of the political process. And nothing prevents the majority leader from saying, okay, I'm going to file cloture on, say, Hochberg. And if you don't get cloture, you know what I'm going to do? I'm going to file cloture again. I'm going to keep doing it until you guys back down. And I'm going to make you come down and talk. There really is nothing preventing that from happening today. And we just live in a world in the Senate where you see cloture filed, and then magically 2 days later, with no debate. I mean, there usually isn't much debate at all. It's usually quorum calls and an empty chamber. You just have this vote pop up in 2 days, and then everybody runs away. Or they set a 60-vote threshold, and you never hear about it again. But in the rules, it doesn't say you can't keep filing cloture and just keep the process going and grind down the minority if they're really filibustering. And that's one thing I don't understand why it hasn't happened. You just don't see that happening. Neither party has done that. I mean, it has happened in the past, but in recent memory, I don't remember that ever happening.
Well, when you said the Mansfield Foundation, I remember Senator Mansfield very well. He was probably absolutely beloved by his fellow senators. He was the most fair majority leader I have ever seen. But I remember also on his watch the filibuster of the nomination of Lyndon Johnson to put Abe Fortas as Chief Justice of the Supreme Court. And I remember how uneasy a lot of people were because they'd never seen a filibuster of a Supreme Court justice. And it was led by Robert Griffin, and it was successful. And then, of course, we learned more about Abe Fortas, and we were probably a little glad that he was not the Chief Justice. And then I saw the filibusters of Carswell to be on the Supreme Court. And that was successful. And the more we learned about Mr. Carswell, we were kind of glad that he wasn't on the Supreme Court. So I don't see filibusters as a terrible thing. To me, they can be very educational.
And I would just like to emphasize that, Brian mentioned the process and how it's broken down, right? And we don't have a process anymore. But, the numbers have been written about, they're out there. But I would just point you to a couple metrics, because metrics do matter, right? You have an overall macro metric. If you just take the number of nominees that have been submitted or proposed to the Senate, have been nominated, and then take the number that have been confirmed, you get a percentage. And that percentage for President Obama is higher than it ever was for President Bush, and it's higher than it ever was for President Clinton. If you look at the ones that have been slowed down, if you look at the nominees who are on the calendar today, the nominees that the pace is controlled by Democratic committee chairmen. And then finally, if you look at any nominees that we've blocked, and I'm not sure that there's been many, there's been 2, I believe, and the Democrats, the current majority, you could say started this, right? But I don't like to go down that road because I think what Bob said is correct. We don't need to get too far away from the fundamental issue at stake, which is how the Senate makes decisions and how it is set up to make decisions. And my argument is going down this road undermines the Senate's ability to work, to great detriment, as Bob has said, to the country.
All right, we have time for one more question. Yes, ma'am.
I have a question.
If you wait for the microphone. Thank you.
My name is Maria Krepenkin from the Bipartisan Policy Center. I have a question to Dr. Wallner and his argument that there would be kind of a breakdown of order in sort of a no man's land if the Senate rules are changed and if it's attempted to make the Senate a more rules-based institution. However, Senate rules are endogenous. They originate within the Senate, and the Constitution doesn't have very many restrictions on the Senate. I mean, it does say the Vice President is the President of the Senate, but it doesn't define the role. So my question is, what stops the Senate from adjusting and creating something more like a Speaker of the House-like position? And sort of, even if it would be in a no man's land for a short period of time, couldn't it just adjust to becoming a effective body again?
Well, I think the Senate does adjust. It adjusts all the time. The Senate has changed the way it makes decisions since its very beginning. And it does it in response to different issues. And yes, it determines its rules endogenously, that means internally. But it does so in response to exogenous or external factors, right? It does that. But it does it together. It does it in a bipartisan way. And because of that bipartisanship, it is inherently stable. Today, we are in an inherently unstable situation because of the lack of mutual agreement and mutual buy-in on how the Senate's going to make decisions. Not necessarily on what the legislation is going to be, but on how we're going to consider the legislation. And this is in twofold. First, we saw prior to this, over the past several years, this majority increasingly use its prerogatives to approximate as best as possible a form of majoritarian rule in the House, right? Filling the tree, substitute for a closed rule, blocker motions to proceed, to block out even extreme efforts to try to get votes on things, filing cloture on the same day a bill is brought to the floor rather than in response to a filibuster. But that has its limits because you still have to entice, you still have to force, through public pressure, a few Republican senators in the minority to join with you to invoke cloture. And so once that breaks down, there's only one other place to go, and that is to get rid of the cloture rule. And that's what we're seeing right now. And that's why it's inherently unstable. And I don't think you will be able to find a sustainable order in this mode.
And if I could add, you say the Vice President could become like the Speaker. I can remember Robert Byrd, when he was Majority Leader, informing the Vice President, Senator Mondale, who was speaking at the time, that he had no right to speak to the Senate, and that only through the unanimous consent of the Senate could the Vice President speak. I will tell you that the Senate has done everything in its power to minimize the role of the Vice President, and they have been quite successful at that. I don't think the Vice President ever could play the role of the Speaker. I can tell you one former Speaker of the House who tried, and that was John Nance Garner when he was Vice President. And he was the reason that the office that I finally held, Senate parliamentarian, was set up because he started making statements that when the chair was authorized to appoint conferees, he would make some independent decision on those conferees. Well, that was not what the Senate had in mind. And they set up the Senate Parliamentarian's Office in 1937 to tame that particular vice president, John Nance Garner.
And one other thing, efficiency is not inherently good. I mean, we don't want an efficient Senate. We want a Senate that works slower so that the American people can participate, because we have this idea of consent of the governed. So, I mean, what always bothers me is I think many people look at the American people and say, you know what, you show up and vote and that's the last we ever want to hear from you. I mean, what really should happen is this is a process that's ongoing where people get to talk to their members of Congress and say, hey, you know that nominee that's coming up? Here's my feelings about that nominee. If you have an efficient Senate, then that will deteriorate. And you also think about taking it to its logical conclusion. Why have any debate at all? Why don't you just let the leader take up whatever he wants and not have any debate, and just have votes and vote on all these nominees, vote in whatever legislation and approved amendments that you want. And I think the answer to that is because we don't want the Senate to work like that. It's never worked like that. And it's been a pretty good institution. I know that the American people look at Congress and they don't like the House, they don't like the Senate. I think one of the functions of that, I mean, it's legitimate to look at Congress and see how messy it is and to be upset about it. But the reason why they have such low approval ratings is because all the deliberation is out in public. The executive branch doesn't do that. All their discussions are behind closed doors. You don't see people fighting and arguing. It's an administration that speaks with one voice, the President of the United States. The Senate speaks with 100 voices. In the House, you have so many members speaking, and it looks like they're all yelling at each other and arguing, but that's the way our founders wanted it, to separate the powers out and to have an inefficient Senate that doesn't get things done very quickly, but does get things done eventually.
Well, that was it. We went a little bit over time, but again, I want to thank everyone for coming, including our C-SPAN viewers, and thank our panel, everyone. If we could give them a round of applause.